All right, let's proceed. Thank you.
Thank you, Your Honor. Kevin Curtin, Assistant District Attorney from Middlesex. On behalf of the Commonwealth, with me is Assistant District Attorney Patricia Gould. This case, members of the court, presents an opportunity to articulate clear and helpful lines between official conduct and private conduct in the context of off-duty police officers.
Mr. Curtin, I understand the argument that he was off-duty, but it does seem to me one cannot ignore the fact that he was in uniform, I believe had a gun, and from the perspective of Mr. Limone, he would be seen as a police officer. So it's not like the jogger.
It's not. It's true. It's not exactly like that case. It's similar to that case in the sense that he was off-duty, and it's actually more helpful for the Commonwealth than the Tynes case, this case, because unlike Officer Hagan and Tynes, this officer never acted in the way that you'd expect a police officer to act. He never tried to develop probable cause. You can't blame him for being in uniform.
That may go to whether there was an arrest and the rest of it, but does it really go to whether it was considered totally private conduct? I mean, the judge didn't treat it that way.
Absolutely, I think it does. I think that is this is the opportunity to draw that line, because we're talking about the application of the exclusionary rule. And there, it's very important to make sure that we're trying to deter official misconduct.
Could the other person have ignored the officer's instruction to stay there and not to drive away?
Sure.
He could have.
He could have. He could have tried to walk away.
Officer in a uniform with a gun.
Well, the officer said, and now this is in the trial evidence, that he would have let him walk away.
Well, what he subjectively would have done, what the...
He was a reasonable person under those circumstances would not have understood that he was under arrest. There had been an accident. A person came up to him, turned out to be a police officer, said, "You hit my car. Get out of the car," like you would normally expect, like everybody does. Let's take a look at the damage. And then after it turns out that he is obviously impaired and should not be driving, the officer, Kelleher, takes the keys away, tells him, "Please have a seat in the car." And that is not outside the sphere of legitimate private conduct. That is not something that a private citizen would not have been allowed to do. And that should be the safe harbor in a situation where, in the first instance, it's clear that he was off-duty. He's driving home. And under the factors that courts have expressed to draw this distinction, they really support the position that he was in a private capacity. Under the Andrews test, which is, I believe, the lead test in the states on this issue, he was off-duty. He was not on duty. And his conduct was far less intrusive than the officer in Andrews. In Andrews, the officer was also in uniform. He was an auxiliary officer. He was in a car that had blue lights. His official car had blue lights, and he used those blue lights to stop the motorist. He then called local authorities, and the court concluded in that case that he was in his private capacity. And in other cases, like in the Tynes case that was just mentioned, an off-duty officer conducts an interrogation which is characteristic of what you'd see in an OUI investigation. This officer didn't do that. This officer didn't stop the motorist when he was driving erratically in Medford. He didn't call and ask if the local police wanted to make a request for assistance, even though he could have. That, as in Twombly, doesn't that suggest to you that he knew that he was not acting in an official capacity and didn't want to? He was confining his conduct to that of a private person.
So what is the line that you suggest we draw? Why don't you define as precisely as you can what that line would be?
So the court really has already defined it in terms of safe harbor. So long as the conduct under Limone does not fall outside the sphere of legitimate private action, then that cannot be official conduct. And here, even just telling the person to get out of the car that is not inconsistent with private conduct, especially if the person is in the car with the window up after an accident. Everybody gets out of the car. That is common conduct among private parties. Taking the keys at the time when it was clear that he should not have been driving and was presenting a grave risk of death, foreseeable death, to innocent third parties, that didn't transform it into some kind of a citizen's arrest or any kind of an arrest. In Moses and in Tynes, the officer took the keys. And that did not constitute an arrest. And the officer returned to his own car, consistent with private conduct. There had been an accident. Police were on their way. He did not coordinate with police. I'm sorry.
So let me see if we can define these lines. If he had, having observed the individual appeared to be driving poorly, put on his blue lights on a private car. He was in a private car, correct?
Yes, he didn't
Okay.
have blue lights in this case, but
But
if he had.
But some police officers do. Put on a blue lights and stop the car. Would that be appropriate? Or would that be lawful? Or would that trigger the exclusionary rule?
That would be like Andrews. And the question is that in Andrews, that was private conduct. And that approach has been, applied elsewhere through the states. And the court would have to consider if that was private conduct or a vigilante-style official conduct. And, I think that in that case, it probably would be private conduct. Even though if he happened to have blue lights and he was doing something that was necessary to prevent a grave risk of harm to the public, and he did that, he utilized the blue lights if he had them to make the stop, that would be a response to an emergency, and it would depend on how he conducted himself thereafter under the second prong of the Andrews test. It sounds like official conduct to activate your blue lights.
Looks like official conduct, would be perceived as official conduct, for sure.
Could be perceived as official conduct. Andrews said it was
By everyone, by anyone.
by anyone. But the capacity in which he was operating was not in the capacity of being an on-duty officer. It was that he was off-duty. He just saw something that required a response by a human being.
Okay, so I'm trying to figure out what this so-called bright line is. Doesn't seem so bright as you describe it. I mean, or at least it's clear.
It's not so bright.
I'll keep clear of its wisdom, but even its clarity doesn't seem so precise.
The safe harbor can be clear. It has to be analyzed in light of the facts. So long as a person who happens to be a police officer, even if he is in uniform, as Kelleher in this case, confines his conduct to that which is legitimate private conduct, then that can never be official conduct. And the exclusionary rule can never apply in that case.
All right, so according to, in view of your safe harbor, if he had cuffed him,
Yes,
that would fall outside your safe harbor.
I think that would fall outside the safe harbor.
Or drawn his gun.
Or drawing his gun. You can't blame him for not taking the gun off or not taking his badge off, or there's no indication whether he had a hat on or not. But because the transaction commenced when he was in his private capacity, he just happened to be in uniform.
It's not a
What about
question
him
of,
ordering the person to stay in the car?
Well, just that is consistent with just take a seat in the car with private conduct. I think that I could say that to a person, just have a seat in the car. And that doesn't transform his conduct into official conduct. And it's similar to as in Moses, we're taking the keys away as an officer safety message decision. That didn't transform it into an arrest.
Well, hypothetically, if there's a car accident and one driver says to the other, "You stay in the car," I think that person would feel like I could ignore that.
I think so.
But if you add in the person who says stay in the car is in a uniform with a gun on,
Well, just have a seat in the car.
don't leave the car.
That is not under arrest. A person would not understand that he was under arrest.
but isn't that a separate question? In other words,
That's true, it is a separate question, but that's the line, that's the official line. A police officer can make an arrest. A citizen can, I suppose, make an arrest. But it's not the type of detention that police officers in their official capacity do on reasonable suspicion, threshold inquiry. The line would be arrest. If the conduct of the off-duty officer acting in a private capacity rises to the level of an arrest under the legal standard, which is a restriction on liberty made with the intent to effect an arrest and so communicated to the person, then that would be the line. And that makes sense. That makes sense because this person was just going through his day as a private citizen, coming home from a private detail. He was rear-ended. He didn't try to coordinate with local authorities. He didn't try to investigate the criminal aspect of the transaction.
He called them on his cell phone. I mean,
He called him, but there's no indication that he told them even that he was a police officer. Nothing in the record suggests, and nothing that I've seen in the papers suggests that he actually told them, I'm a police officer. And he didn't tell, even though there is a finding in the judge's findings that he announced himself as a police officer, that is actually not supported by the record. He did not do that. He was asked specifically, did you tell him on page 9 of the motion? He said he did not. The judge must have misheard. 3 pages later on page 12, the same no. The officer responded no to a question, and the judge said, excuse me. And so, did you tell the defendant that he wasn't free to leave? Did you conduct any further investigation yourself? Question, answer, no. The court, I'm sorry, no, ma'am. Okay, so the court.
But he's wearing a police uniform.
He's wearing a police uniform.
So, I mean, isn't that generally enough from the perspective of a driver that one recognizes that a person in a police uniform, if it's not Halloween, is a police officer?
But for the purposes of the exclusionary rule, it's the perspective of the police officer.
Well, but, I mean, are you saying that for the purposes of the exclusionary rule, Judge Kottmeyer says at the end, you know, it's unreasonable searches and seizures, so even if you call this a seizure or stop, whatever, it's not unreasonable, and therefore the exclusionary rule shouldn't apply.
That's true. That's
but
right.
you're going beyond that, right?
Well, before you even need to get to that, he knew that he wasn't authorized to act outside his jurisdiction. He knew that, and he didn't. There's nothing to deter.
What you're saying is he didn't act beyond what a private citizen could do.
Precisely.
Regardless of whether the individual said, oh, he's got a uniform on. It could be a fire department uniform, a National Guard uniform, a state police uniform. Beyond what the person may have thought, he didn't act beyond what private persons could do.
That's exactly right. And that's what counts. That's what should count for purposes of this distinction in the application of the exclusionary rule. And that's the line that I think that I suggest that the court apply in this case. And it is true also, moreover, that that even if this were official conduct, which it really wasn't, that it was not unreasonable under all the circumstances. You would look at the traditional factors for determining reasonableness, the degree of the intrusion measured against the urgency of the situation, and I suggest to you that it's really beyond serious dispute that given the grave risk of harm to the public, the limited intrusion that took place here was not unreasonable. There are statistics that are in the amicus brief that I commend to you that show the urgency and demonstrate of the situation. And you can see for yourself the limitation that Kelleher imposed upon himself.
So if I understand correctly, you would say even if Mr. Limone perceived this as an arrest and under the sort of standard of would a reasonable person think he wasn't free to leave, even if Mr. Limone reasonably thought he wasn't free to leave because of all the details, that's really not critical. That's not even maybe perhaps relevant. What's relevant is, did the actual actions of the officer, whatever the defendant might have thought, did the actual actions of the officer exceed or not what a private person could have done?
I think that's right, Your Honor. I think that's right. And that should be the safe harbor. That is something that police officers can recognize. It was recognized in this case. It's helpful to announce, and it provides stability.
Your time is up. Thank you, sir.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court. My name is Robert DiOrio, and I represent Mr. Limone in this case. I'd like to first start up just briefly touching and emphasizing some facts. Throughout this whole encounter between the officer, off-duty officer, Mr. Limone, I emphasize he's got a badge, he's got a gun, he's got a uniform. So I would suggest that anything that he did wearing the indicia of state authority, i.e. a badge, a gun, a private citizen can't walk around and...
What's he to do? He gets hit rear-ended. He's supposed to take his uniform off, strip down, and go over so he doesn't have a badge?
Absolutely not, Your Honor. Absolutely not. And let me just touch on one of those facts. There's a light tap with no damage, first of all. It's not like we got a rear-end crash. The officer gets out...
A light tap. I've been tapped. I've tapped others. It's a stop.
Me too. No question, Your Honor. But the officer got out and claims that he made the observation that Mr. Limone was under the influence. So he tells him to get out of the car, and he takes the keys. He then goes beyond what a private citizen would do. He tells him to get back in and wait, and he calls the police at that point. Now, you know, we all see the commercial, friends don't let friends drive, drunks take the keys, etc. If it stopped there, maybe the Commonwealth would have more of an argument. But when you do the fact-sensitive analysis of this case, clearly Mr. Limone doesn't have any reasonable belief that he's free to leave.
Well, how could he be, oh, you're saying he could be free to leave because even though this person has his keys, he could stumble off?
One of the arguments was that the officer made is that I would have let him go. Of course, Mr. Limone didn't know that. And Mr. Limone was ordered by a police officer to wait. And he complied with the police officer. And a private citizen in the same situation would have had the ability to exchange paperwork with the other operator, typically name, registration, and address, and you're free to leave. In fact, there was no damage here. So
But he could have, but are you saying that the private citizen couldn't say, if he perceives this other person to be drunk, give me your keys?
The private citizen could say that, but I think the important fact that's missing is if the private citizen is wearing a police uniform and a badge, I think it has to be viewed in a different light. At this point, are we talking about some sort of civil tort of a false arrest or false imprisonment? I mean, you know, isn't it misleading to the average citizen? I mean, and again, I agree. If he had civilian clothes and there was no indication whatsoever that he was an agent or officer of the government in any way, shape, or form, if it was closer to Tynes, then I agree. I agree with the Commonwealth's position. But when you add the police uniform and the color of law behind everything this, quote, citizen says or does, it has to be viewed in a different light.
So what are we deterring? If we exclude the evidence, what are we deterring? What kind of official misconduct
You're deterring vigilantism.
This is vigilantism, is what you call it? This is vigilantism.
I don't think you can draw the clear line, Your Honor, because you've got a gentleman, an off-duty police officer, who, again, acts under the color of law.
Because he's wearing a uniform.
I understand.
So we go back. Should he have taken the uniform off before he got out of the car?
I'm not going to make that. I think that would be ridiculous. He's not going to cover the badge up and do that, Your Honor. But the point that I'm making is that in Greece, this court expressed the same concern the DA has just expressed, and that is that we are concerned about the danger of drunk driving. But before we expand the authority of a police officer to engage in this conduct outside of their territorial jurisdiction, we have to also take note of the potential for anarchy and vigilantism. And I'm not suggesting in this case that this was a rogue police officer, a cowboy cop, so to speak, but once you open the door for this type of activity, I think you open a Pandora's box.
But what about from the perspective of the defendant in this case? He's in his car. There was just a light tap. And if this man really were a police officer, or if he was being treated or manipulated by a police officer, the man has to be saying to himself, well, gee, he didn't ask me for my license. He didn't ask me for my registration. He didn't ask me to step out of the car and do any kinds of field sobriety tests or anything like that. He's doing things that police officers don't do, as a matter of fact.
Well, I would disagree, Your Honor. I handle a lot of OUI cases. It's not unusual for a police officer to call for backup. It's not unusual for a police officer to take the keys away and say, wait in the car. I'm sure you've seen enough appellate cases under 9024 cases where that is not unusual. So I would disagree with the premise of Your Honor's question. Clearly, this man did what a police officer would do. He detained Mr. Limone. He called the police, and the police arrived. The police then participated in the investigation that was started by this off-duty police officer. And could I just throw this out for Your Honor's consideration? Once you open up this sphere, this private sphere of conduct that the Commonwealth suggests that you do, you should consider the following. And let me use a hypothetical. The officer says to Limone, stay in the car. Limone gets out of the car. The officer grabs him. There's a fight. The officer gets hurt. Have you considered the ramifications under Chapter 41, Section 111F? At this point, well, in what capacity does the officer act? Is he a private citizen? Is he an officer? Is he covered for the injuries? What does this do to the tort of false imprisonment, malicious prosecution? Have we considered those things? Let's go a step further.
But the issue in this, those aren't the issues in this case.
Yes, they are, Your Honor. I think
really, the issue isn't whether or not he violated the Fourth Amendment.
The issue is whether he violated the Fourth Amendment. I was addressing the Commonwealth's point about trying to carve out this bright line, this private sphere of conduct that they're requesting that the court more carefully define to permit a police officer off duty to do what this officer did. And I'm simply asking the court in deciding whether that is reasonable to consider the other ramifications. And again, those would be such things as what do we do? The other thing is, if you look at Chapter 90, Section 21, it's fairly specific. It lays out that a uniformed police officer with a badge, I forget the exact language of the statute, can arrest for the misdemeanor of operating under the influence. And there's nothing in that statute that says the officer can do it outside of his jurisdiction. You look at Chapter 41, Section 98A. It talks about fresh and continued pursuit outside of the jurisdiction. And this court, as I understand it, has consistently stated that if that authority, if that arrest authority is to be broadened, that's something that should be left.
Yeah, but Mr. Curtin isn't arguing that it be broadened.
I think he is, but
Well, I mean,
that's how I understood it, certainly.
I mean, I think what he's saying, you see a distinction between this case and the Hernandez case, right? Do I have the name right? The one that we decided last year.
It was the 2010 case, yes.
I mean, there is a big difference, don't you think, between these two cases?
In terms of facts?
In terms of the problem there is that the officers were doing something that the private citizen would not have had the ability to do, and acting on it.
I understand that. And I agree with Your Honor.
I mean, I think Mr. Curtin's argument is there's nothing that Officer Kelleher did that was different from what a private citizen could do. The perception of Mr. Limone is different, absolutely, because of the uniform and the gun, no question about it. But in terms of conduct of the officer, there isn't.
I agree. I mean, look, it would defy common sense if I stood here and told you that the officer didn't do what a lot of private citizens would do. But the difference is that with a uniform, acting under color of law, it has to be viewed in a completely different light. And for those reasons, the officer acted outside of his territorial jurisdiction. He didn't have the authority to do what was in effect an arrest. I mean, clearly it's...
Can I get you to
you
just address the point I've been puzzling over?
Sure.
So the officer took the car keys.
Correct.
Now, if a private citizen took car keys from another private citizen, I assume that the second private citizen could choose to use self-help to get their car keys back.
They'd be legally permitted to do it.
But if they do that with a police officer who's confiscated their car keys, they're running a big risk, aren't they?
Sure they are. Now they're running the risk of charge with assault and battery on a police officer. You get into, I mean, typically people can't use self-help to resist even an unlawful arrest. It's a legal nightmare when you get into that domain. again, in a Fourth Amendment analysis, and Justice Kottmeyer alluded to this, typically the analysis, well, was it reasonable under the circumstances? And maybe I didn't make the point as well as I could have earlier, but I think, Justice Ireland, that's one of the points that has to be considered. When you determine whether the officer's conduct was reasonable in terms of a Fourth Amendment analysis, you've got all these other considerations.
What shouldn't the officer have done? So I'm just trying, what was the misconduct, the official misconduct at stake here?
Well, I would suggest he had no right to take the keys. He had a right to request that Mr. Limone
Stay. Wait for the police.
He had a right to make that request, but I think after that, Your Honor, when he told him to get out of the car and took the keys and told him to get back into the car, I think he went afoul of the law at that point. And frankly, Your Honor, in the everyday world, can you picture yourself going up to somebody that you think is drunk and potentially dangerous and ordering them around? You're only going to...
Someone who hits me? Oh, I think I might say there needs to be a little control here, buddy. You sit down right there, I'm calling the cops.
Well, you're a more brave man than I am, because you don't know what that person is going to do or how they're going to react. Typically, you're going to get on your cell phone and you're going to call the police and you're going to get a description and you're going to wait. And again, to permit the...
On the circumstances, I suppose. Depends on the circumstances.
Right. And again, we're talking about, if you read the transcript, a tap so light that there was no damage. There was barely any jolt. We're not talking about a violent accident. There was no damage. And what the officer had the right to do as a private citizen is request, again, under the statute, the name, the residence, and the registration. And that was it. That's all a private citizen would be or allowed to do in that situation. Anything beyond that, at this point, we're talking about false imprisonment.
Well, wait a minute, let's go back.
Sure.
You talk about friends don't let friends drive
Right.
and everything. So maybe the private citizen might try to persuade the person,
Absolutely.
maybe you shouldn't drive, give me
Absolutely.
your keys.
Absolutely. Hey, look, you've had too much to drink. Can you sit in the car and wait? Let me get you. This officer took a very authoritarian approach, and frankly, he's off duty. He's wearing a police officer. He did what police officers do, but he was outside of his jurisdiction when he did it. And if we...
If I could flip it over for you, though, let's say the officer didn't take the keys and the person drove and hit someone and caused an injury, then there'd probably be some kind of lawsuit for the officers allowing someone they perceive to be under the influence to go away. We've had those.
Irwin versus Ware PD, I think, is a landmark case.
That's right.
But, here we've got an off-duty police officer who is acting as a private citizen, who is under no duty at that point, who doesn't have the authority to exercise that power. So, frankly, I don't see that case is going to get off the ground. And certainly, if he's called the local police department, he's brought it to the appropriate authorities' attention, he's done everything that would be reasonable under the circumstances. I find it hard to believe there'd be a negligence claim there. Certainly not against him personally under Irwin versus Ware PD, because that's an action against police officers. He's not a police officer in this situation. He's acting as a private citizen in this situation. And, one of the things I'd like to remind the court...
So you're saying it would be unlawful for somebody not wearing uniform to have the same thing happen, to see that the person appears to be intoxicated, and to ensure that the person is going to wait a few minutes until the police officer can come to investigate, that would be unlawful for that person to hold the keys and tell the person, let's wait for the police officer to come?
Yeah, I think if that person's wearing a police uniform...
No, let's assume he's not.
Oh, if he's not wearing a uniform, I think you would border into the area, arguably, of a false imprisonment.
Okay.
Which would be a civil tort. When you say illegal, not a crime.
Okay, but you would never, as a plaintiff's lawyer, bring that case.
I wouldn't bring that case. There are no damages.
And nor would anybody else.
I agree, Your Honor. I agree.
Is it unreasonable? I mean, didn't he do what we actually want him to do, is to make sure that a dangerous driver doesn't return to the road until a police officer has had a chance to arrive at the scene of an accident and check it out?
But see, there I disagree with you again, Your Honor, because what throws the premise of your question off is that he's wearing the police uniform, the badge, and the gun. We can't get around that. So the question then is, do we want people walking around outside of jurisdictions? Do we want a guy from Nevada? Hey, I happen to have my uniform. Making these types of decisions in Massachusetts. Do we want to promote that? And that's really what we do if we permit this, Your Honor. And look, at first blush, I can't escape the fact. At first blush, you look at this, you say, gee, the officer did what most people would do. Absolutely. Okay. But when we look at the ramifications of it, the constitutional ramifications and even the practical ramifications, I'd suggest that his conduct was unlawful.
Well, in time, you focus on taking the keys. In times, the officer took the keys.
But he's not in uniform, Your Honor. He's in a jogging suit.
Okay, but we're talking taking the keys. Can a private citizen take the keys in these circumstances?
No, at that point, they commit a conversion, potentially a larceny, a civil tort, perhaps, of false imprisonment. I suppose it's a larceny. It's the unlawful taking of the property from another. I mean, again, I think we open
No intent to permanently deprive, however. But that's another.
Well, I think there's certainly probable cause to bring that charge, Judge. But, well, I see my red light is blinking. Again, I thank you for your questions and your careful attention to this case.
Thank you, sir.
Thanks.